Jonathan Pollard, competition lawyer, Fort Lauderdale, Florida. Today's topic, laid off from work and stuck with a non-compete agreement. So over the past several months, millions and millions of Americans have been laid off, furloughed, let go. They have had their salaries cut, their wages slashed, and yet at the same time, they remain subject to or potentially subject to non-compete agreements. Folks, this is a problem. If you have not followed my work in this area of law over the past decade, I have dozens, if not hundreds, of articles, blog posts, videos, continuing legal education seminars that I've taught to other lawyers where I break this all down. But to give you the short version of what you could spend literally a month of your time studying, just my content and sort of my case law alone, America has a non-compete problem, and over the past 30 years, it's turned into a non-compete crisis. The crisis is particularly acute in certain jurisdictions, namely Florida, Texas, a couple of other states are hot spots for non-compete abuse. How did we get here? Well, 30 years ago or so, management side lawyers at corporate law firms began pushing non-compete agreements to be used all the time in every industry at every level. Because if we go back 50, 60, 70 years, at that point in time, non-compete agreements were generally utilized only for key employees, high-ranking executives, officers, etc. Those were the folks who were highly compensated, truly had the keys to the kingdom, the secret sauce, the formula for Pepsi, right? Those were the folks who had non-compete agreements. But over the past several decades, the situation has morphed into one where everybody has non-compete agreements in every industry, at every level, in every job capacity, no matter how absurd it may be. This is why we're now in a situation where hairdressers have non-compete agreements, doctors have non-compete agreements, janitors, factory workers, security guards, engineers, journalists, interns, car washers, everybody has a non-compete agreement. The problem is that there are a whole lot of rich, powerful people who have made a lot of money off of this abusive scheme and continue to make a lot of money off of this abusive scheme. In my view, this is the most important economic justice or labor justice issue of modern America. And for so long, it has flown under the radar because rich, powerful people abuse non-compete agreements and make money off of non-compete abuse, and they simply don't want to talk about it. Talking about it is frowned upon in this establishment, and it makes one public enemy number one, right? So when I go out there on my crusade against corporate non-compete abuse and corporate lawyers pursuing abusive non-compete cases, which they make a tremendous amount of revenue off of, it makes me sort of public enemy number one. I'm basically the boogeyman to all of these people. But at the end of the day, I have a legitimate axe to grind. I have legitimate contentions here. We're looking at labor market collusion. We're looking at labor market concentration. We're looking at restricting fair and ordinary competition, preventing employees from going and finding a better job, making a higher wage, and ultimately what we're talking about is companies colluding in this massive wage suppression scheme. That's what this is all about, folks, and I'm not the only one saying it. There are professors at Harvard Law School saying it. There are professors in the economics department at prominent universities saying it. There's folks at the Federal Trade Commission saying it, and there's folks at the DOJ saying it. The only problem is I got here about a decade early and started telling folks how this went down and what was really going on, and nobody wanted to pay attention. But now, surprise, surprise, everybody's talking about it. Talking about it is not enough. We have to start doing about it if we actually want to fix this corruption and greed and dysfunction. And so where are we right now, November 2020? Well, there have been millions of folks who were laid off, okay? And over the past several months, we've had sort of fits and starts in the economy where, things look like they're coming back and then sort of things go back down, come back up. We're in a period of economic turmoil and economic upheaval. And so a lot of these folks have been laid off. And not only that, many of them, because my office receives countless messages, inquiries, phone calls in any given week. So I really do have my hand on the pulse of this. I have my hand on the pulse of this so much so, and not just this issue, but a number of sort of related issues, that there are journalists from national publications who call me on a regular basis and just say, "Hey, Pollard, what's going on down there? What are you seeing? You seeing anything interesting? You seeing anything I can write about?" Happens all the time, right? Regulators call me as well and say, "Hey, what are you seeing? Can we talk about some of these issues?" Why? Well, because I get such a massive volume of inquiries and stories and narratives and information. So I really have a good sense of what's going on out there. And so one of the things that I'm seeing is not just companies laying people off and saying, "Hey, we laid you off, yeah, but you're still subject to a non-compete agreement." I also see these companies laying folks off and then saying, "Hey, well, we laid you off 2 months ago. Things are starting to improve. And we're willing to offer you your old job back, but just at sort of half of what we were paying you before." And when the person says, "No, I really don't think I can survive like that," the company says, "Well, you better take this deal. And if you don't, remember, you've got a non-compete agreement and we will enforce it against you and come after you." So let's look at what are the incentives driving this sort of behavior, because that's important to understand, okay? First, you have the sort of corporate incentive, okay? These companies are already struggling. They are deathly afraid of losing any revenue. They are deathly afraid of competition, even if it is just sort of outright regular competition. We're not talking about somebody stole some trade secrets, somebody stole some documents, there's anything proprietary, exclusive, protectable. We're just talking about somebody leaves the company and goes to work for a competing staffing and recruiting agency and is staffing and recruiting for jobs that are publicly posted on LinkedIn or Indeed, right? That's a great example of what we're talking about. No sort of unfair competition whatsoever. But these companies are so deathly afraid of any competition. They have been using non-compete agreements to stifle fair and ordinary competition for the past 2, 3, 4 decades. They're so used to it, they've used non-compete agreements to obtain an unfair advantage in the marketplace and to eliminate regular and ordinary competition. So they're terrified, they're trying to get a leg up, and they're particularly spooked given all of the economic turmoil. So whatever revenue streams they have, whatever money they have, whatever business they have, they are incented, they are highly incented to protect that. But there's a second part to it, okay? If these folks, these companies, okay, that are so concerned about, the revenue and money and their bottom lines, their business, clients, etc., if they're so concerned about these things, then they probably want to avoid a lot of the non-compete litigation that they're getting into. So the second part of who's driving this and who's pushing this is the lawyers who, in many instances, in my opinion, are just hungry for some work, right? I've had, over the past few months, numerous conversations with other lawyers and sort of law firms, associates in big firms, counsel, partners, what have you. And I've heard so many stories about lawyers, particularly corporate side lawyers right now, latching on to whatever cases, clients, or business they have, and basically saying, hey, bill the heck out of that case because, that's all we've got right now and we need to make some money. So the lawyers or the other sort of business folks who look at me and say, how dare you say that? How dare you say there's lawyers out there sort of just pushing litigation or advising clients to pursue a certain strategy just to make themselves money. You expect folks out there to believe that that's not happening? You think that suggesting some lawyers are pushing litigation or pushing strategies just to make themselves money, you think that's not happening? There are a litany of cases and of newspaper articles that you can go read. Everybody remembers the sort of churn baby churn case where some big firm got popped for fraud billing. It happens. And in my opinion, which I'm still entitled to express as an American under the Constitution in this country, right? I will tell you unequivocally, it happens. And it happens with what I think is disconcerting regularity. But so in that direction, company A goes to a law firm and they say, all right, Joe Smith, used to work here. He went to a competing company and we're afraid that he's going to take business from us. And, we want to sue this guy. We want to sue the crap out of him and bury him and shut him down and make sure he can't solicit our clients in our business, right? Any lawyer who is truly, one, competent in this area of law, and two, an actual fiduciary who puts their client's interests first, is going to advise that client regarding the full risk-reward framework, okay? I have been involved in so many non-compete cases where ultimately the other side starts it, okay? The other side starts it. The other side either sues my client or they send a cease and desist letter. They get my client fired from his or her new job. They start it, okay? And then, we get in whether or not the person can afford it. I mean, yes, we have, cases where it's, we're litigating for $20 or $30 million, okay? We have, sophisticated paying clients. But then on the other end of the spectrum, we represent tons of folks who, can't afford to pay us $1, okay? Simply because it's the morally right thing to do, to provide counsel for these people who are otherwise helpless and defenseless, right? That is the right thing for lawyers to do. And so we get involved in a lot of these cases where the company started it, we get in, and immediately when I get in, I often send correspondence to the other side, to the plaintiff, to the corporate lawyer, and I explain to them, okay, so here's the facts, here's the law, and I know you might be used to filing non-compete cases in Florida state court and either, one, having no meaningful opposition, two, having an opposition that just taps out and agrees that you get your injunction however you want to write it, or three, courts that routinely misapply this area of law. And that's well documented, right? You can look it up. Trial courts in Florida routinely get reversed in non-compete matters because this area of law is very complex and poorly understood and routinely misapplied. And in my opinions, or from my research, there are even more trial court non-compete injunctions that are clearly erroneous but never get reversed because the person is poor and they do not have the resources to obtain counsel and pursue an appeal. But so this happens all the time, and so it's emboldened both the companies and their lawyers. And so their lawyers are often advising them to pursue these non-compete cases, file the lawsuit, seek an injunction. We're going to railroad the other side. in the course of my practice, I have been involved in a number of these cases where I found out on the back end that the corporate plaintiff went to their lawyer, and their lawyer told them that they could get it done and shut the other side being my client, shut us down for $1 certain. And that dollar invariably was a low dollar figure, right? I had one case several years ago where the client went to a big law firm in South Florida, and the big law firm told them they could shut my client and his new company, which was now making millions and millions of dollars already, okay? Not doing anything unfair, not using any proprietary information, no protectable relationships, just fair, outright gloves off competition, okay? My client was already making millions of dollars. And so big firm in South Florida told the plaintiff $100,000 and we will shut him down, get a massive judgment against him. Well, they wound up spending over $1 million and they lost. Happens all the time. Well, why? How does this happen? Okay, how could they possibly spend $1 million in lawyer fees on a case where they were telling their corporate client it'll be $100,000, and how could they possibly lose? Well, it's because one, most lawyers do not really understand the correct doctrinal antitrust framework that governs these types of cases. But even beyond that, many lawyers fail to comprehensively assess the risk framework. In fact, in many of these cases, I question whether or not they did any risk assessment whatsoever. And to me, that's just mind-blowing. But there are plenty of cases where plaintiff comes in, files a frivolous non-compete case where there's fee exposure, meaning that the loser pays, okay? So the fee exposure exists either under the contract or under the non-compete statute, and in many cases it exists in both places. And I've been involved in so many cases where the lawyer on the other side did not understand that there was fee exposure. In fact, you often see a situation where the operative contract or operative non-compete agreement is written in a way that says, if the company has to sue under this agreement, they are entitled to recover their reasonable attorney's fees. And I have had corporate lawyers basically laugh in my face and say, well, how are you going to get attorney's fees out of this case? Because, read the contract. The contract says the company is entitled to recover its reasonable attorney's fees. The contract doesn't say that the employee is able to recover their attorney's fees. So, we're just going to hold them to the contract. Can't do that. It's Florida statutes 101 or 105. It's part of that same statute. It says if you have a one-way fee provision, it turns it into a two-way fee provision. And so you have folks out there firing off these lawsuits without even evaluating the risk framework. And one of the most significant risks there is attorney's fee exposure. I have some of these cases where I'm not talking about sort of big, cases on behalf of paying clients and where there's millions of dollars at issuance or C-level executives. I'm talking about cases on behalf of working class, poor, middle class, or regular people who I have represented for free at no charge to them on a contingent hourly basis. I have cases of that nature where my firm has easily put in $200,000, $300,000, $400,000, $500,000 in attorney time. And that is just the base number, right, in terms of whatever our regular hourly rates are. That says nothing of a fee multiplier. And so then people start saying, fee multiplier, what are you talking about? Yes, fee multiplier, right? This is what makes you in America today, and particularly in a state like Florida, right? This is what makes you a crazy person, right? When you start telling people, no, this is what the law says. And they flip out and they basically have a meltdown and they say, oh my God, you're a crazy person talking about fee multipliers. Look it up. It's in the law. When I represent sort of poor and indigent people who cannot otherwise afford to hire counsel, and but for me stepping in and agreeing to represent them or defend them in a non-compete matter at no charge, no money out of their pocket, not even $1, not even paying for costs. I just say, look, I get it. You don't have the funds. This is immoral. This is injustice. I'm going to represent you. I'm not going to charge you anything, right? And my firm will put in $200,000, $300,000, $400,000 of attorney time, $30,000 of sort of out-of-pocket expenses for depositions, transcripts, discovery, document collection, court reporters, expert witnesses, travel, printing costs, Westlaw access, Pacer access. And we just front it, right? When I do that, I am entitled to a fee multiplier, okay? And that means if my firm spends regular sort of base number, call it $250,000 in attorney time on a case. That means there's a very compelling argument under existing Florida law that I should be entitled to a 2 times or even a 3 times multiplier. And it's coming, right? I can feel it coming in the air tonight. Oh Lord, it's coming, right? Because what I'm going to do is invariably somebody will insist on going the distance in one of these cases where I'm seeking a fee multiplier on something totally egregious, right? The non-compete is clearly unenforceable, or the person wasn't even competing and got sued for it. I'm going to take one of those cases all the way to the mattresses, and I am going to get a fee multiplier awarded by a court of 2 times or 3 times whatever my regular fees are, and then I will get it upheld on appeal. Okay, that's what my game plan is. And the funny thing is, I'm not telegraphing anything. I'm telling people what I am going to do. And so I have done this over the last several years, where I have basically, in YouTube videos or in articles or blog posts or presentations, I have literally sat there and sort of mapped out, okay, here's like what I'm going to do and what I'm going to sue these people for next, and sort of how I'm going to build this case law and change this area of law and get these judgments out there. This is what I'm going to do. And so many people that I come up against in litigation, they're entirely clueless to sort of my body of work, and they think that it's all a joke and they think that it's all posturing. But so the bottom line there is there's massive fee exposure, right? Especially against somebody who knows how to litigate these cases, who's willing to fund these cases, invest in these cases, and can ultimately seek a fee multiplier. So if it costs me $250,000 in attorney time to litigate a case like this, on the back end, I'm going to turn around. I'm going to say I want $500,000, I want $750,000 in fees, and I can line up 20 lawyers around the state of Florida, many of them highly respected, some of them from big Florida firms who are often my adversaries, who will come in and testify, and they'll say, yeah, Pollard's normal hourly rate is $700 an hour at this point. That is eminently reasonable. And based on sort of his work, his pedigree, his background, he should be entitled to a fee multiplier, right? I can do it. I can line it up. That's strategy. But that's the kind of risk and exposure that these folks often are completely overlooking. So they will file a non-compete lawsuit against a person. Staffing and recruiting context is a great example. I see those all the time, even though it is so egregious and in my view clearly unenforceable. So they'll file a lawsuit, okay? And they'll spend $15,000, $20,000 on the front end to pay their lawyer, put together a lawsuit, file a motion for a temporary injunction. And they'll be thinking, okay, so $20,000 you pay the lawyer, and so they're going after this business, and maybe we stop them from going after that business, which would have generated, X number top line gross. And often they're only thinking about the top line number, and they don't actually do any calculations or discounting, where I've heard people say something like, well, he stole $400,000 worth of business. But the margin on that was 10%. So he didn't steal. First of all, I dispute that he stole anything. He didn't steal anything. These are free-for-all customers, a highly competitive market. The customers can do business with whoever they want. They chose to do business with Fred. But the value of that business, no, it was not worth $400,000. The margin on that business was 10%, so it was worth $40,000. So basically, you got yourself twisted. And on the front end of this, when you gamed it out, you thought, my God, Fred just stole $400,000 of our business. He could go steal another 400, another 400. That's over $1 million. We have no other alternative. We have no choice but to litigate this case. You pay your lawyer $15,000 or $20,000 to go be your bulldog. And then if you run into opposition, and it starts becoming a sort of time-intensive piece of litigation where the other side is really willing to fight at every turn, and then you get countersued, and now you're in a position where you have massive risk, you have massive exposure, okay? But a lot of these companies and a lot of these corporate lawyers do not vet these considerations. So, where does that lead us in terms of actual strategy and solutions and guidance? Well, a couple considerations. Okay, one, anybody who is laid off in the middle of a pandemic, in my view, maybe not in Florida, but certainly in many other parts of the country, I think courts will be highly sympathetic to those sorts of considerations. You can't lay people off in the middle of a pandemic, tell them, hey, we don't have the work for you, you can go get another job. Sorry, Bob, we know you have a family to feed, but we can't keep carrying you. We're all losing money. In that kind of a situation, I think it's immoral. I think it's inequitable. It's a miscarriage of justice for courts to enforce non-compete agreements against folks who have been laid off. That's one. And so you have to raise those equitable defenses. You have to raise public policy defenses. And I know that in many states, they frown upon public policy defenses, and public policy defenses are basically a throwaway, but they should not be treated as such because it does raise a substantial public policy issue. Are we going to support and approve a policy of companies laying people off, in many instances, forcing these people to go on unemployment or other public benefits when they could be out there getting a job and working? That's a massive public policy problem, and somebody ultimately needs to run that to one of the Florida appellate courts, probably the 4th DCA or the 5th DCA, and see what they have to say about it, because I think that is a meritorious argument. You can't force people out of work, put them on unemployment, make them sort of subject to public benefits, all because of a non-compete agreement. Basically, that's the government and the state sort of subsidizing corporate America's non-compete abuse by sort of supporting people who are out of work who otherwise could be working. It's absolutely mind-blowing. So you have to run that equitable defense. Whether or not it's successful, really depends on where you're at. Probably won't be successful in many Florida courts, but certainly in places like New York, North Carolina, Illinois, I see it having a lot of traction. Number two, no matter where you are, including in Florida, if you were laid off, if your salary was reduced, if your commission structure was changed, I'm seeing all these sort of things happening. It all goes in the same direction, where basically, the company changes the deal and is taking money from you. You need to vet, one, affirmative claims for breach of contract and unjust enrichment. But in addition to affirmative claims, you also need to vet the sort of defensive strategy of whether or not these claims give rise to prior breach of the contract. Prior breach is still a very real, live thing in virtually every jurisdiction. If the company breaches the contract first, now admittedly there are some exceptions based upon how the contract was written. These are exceptions that I completely disagree with and find legally and analytically incoherent, but there are some exceptions based on the appellate case law. That said, prior breach, depending on how the contract is written, is a viable defense. So if the contract says the company is going to pay X dollars an hour or X dollars a week, and in the middle of the pandemic, they said, hey, we're just unilaterally reducing this to, half of that, potentially there's a claim there for prior breach. Even if there is not a claim there for prior breach, there's definitely an unclean hands argument. There's definitely other equitable defenses that you can raise. Number three, whenever you're vetting any kind of claims or defenses in this posture, you almost certainly want to vet a Fair Labor Standards Act claim, an FLSA claim. Over the last several weeks and several months, I have seen countless instances where, one, folks were misclassified. They were classified as 1099 independent contractors when they clearly should have been classified as W-2 employees. That type of misclassification opens the door for a variety of claims. The most obvious one is if the person worked a significant amount of hours, if they were working what would have otherwise been overtime in excess of 40 hours per week. In that context, you really have to evaluate, what the job was, what their position was, what they were doing, and determine whether or not they are exempt from overtime or whether or not they would be required to have been paid overtime. And in many instances, folks who are wrongly classified as 1099 independent contractors should have been W-2, worked tons of overtime, and would not be exempt under the FLSA. There are a variety of other claims that you can fashion, some of them sort of particularly gnarly based on misclassification as an independent contractor. There's also some tax fraud claims where there is a private right of action based on the company falsely reporting your earnings to the IRS. But the bottom line is that, number one, contrary to sort of my original prediction, I originally predicted that as a result of the pandemic, companies would be far more hesitant to waste time and money pursuing what is largely frivolous, bad faith, non-compete, trade secret, trademark litigation. I was completely wrong about that, okay? They are desperate to protect whatever advantage or perceived advantage they have in the marketplace. And so if Joe Schmo leaves the company and starts a competing staffing and recruiting agency, even though all of the customers post all of the jobs on Google and Indeed and LinkedIn, the company's going to have a panic attack and call a lawyer, and the lawyer's going to say, "Oh, we absolutely have to sue. Let's go, let's litigate it." That's going to happen, right? I was wrong. I thought it would slow down. I thought reason would prevail. I thought people would say, "Hey, we don't have the money to sort of pour into frivolous litigation." Nope, still going. In fact, it is probably every bit as busy on that front, if not busier. It's probably actually ratcheted up because so many companies are so desperate. And in this posture, companies are often looking for the fall guy, right? They can't, and a lot of this implicates emotionalism, ego, sort of logical fallacies, everything else that goes in that direction. You have so many companies where for a variety of reasons, including sort of just general economic turmoil, global economic downturn, the pandemic, you have so many companies that in looking at their business and their revenue and sort of why things are not going well, they can't just accept the obvious answer of, one, there's a global pandemic, there's an economic downturn, or, maybe I'm making some mistakes. Maybe I'm not doing things the right way. Maybe, my business practices aren't the best. Maybe my customers aren't happy with our work, right? Rather than looking inward and doing any kind of introspection, they are looking to latch on to any external explanation they can peg. And if the pandemic global downturn's not enough, because they have friends whose businesses are doing fine, it hurts their ego to say, well, the pandemic can hurt my business. They have to find some scapegoat, some fall guy. And so Joe just left the company and, look, we're losing all this revenue, so Joe must be to blame, so we're going to go after Joe. And so it makes us feel better about ourselves, and it doesn't bruise our ego, but it's going to bruise your wallet at the end of the day. So one, I was wrong. There's as much of this going on as there ever was, if not more. And to that end, we need more lawyers to step up, and particularly to take cases defending poor people, working class people, middle class people in non-compete disputes who really can't afford to obtain competent counsel. I had a client I represented pro bono for free, and got her case resolved pretty swiftly in a non-compete matter. And one of the reasons why, even though I was incredibly busy and didn't really have the time for it, one of the reasons why I took her case and sort of wound up doing all the work on it myself, which is unusual. I normally have my colleagues do, the vast majority of the sort of briefing and drafting and discovery. But this case, I knew we didn't have time for it, but I took it on anyway. Why? Because some other lawyer had basically attempted to charge this woman, $5,000 to go try and negotiate with the other side. And this is a person who is indigent, right, and had basically no money to her name, was going to have to sell her car to come up with that money. And I couldn't live with that. I couldn't sleep at night, sort of letting that kind of advantage taking happen. So I just took her case pro bono and got it resolved. So we need more lawyers to step up and do pro bono work of that nature. And it doesn't just have to be pro bono. You can do it pro bono for the client, for free for the client. And there's absolutely nothing wrong with you doing it for free for the client, not charging the client $1 up front, but then seeking fees from the other side on the back end. That just needs to be put into your engagement letter that, look, the client doesn't have to pay anything, but if you prevail, you are going after the other side for all of your fees. I find it, highly suspect that in, cases like this, the other side, I've had many lawyers on the other side, corporate lawyers, throw it in my face and say, well, you're not doing it for free because you're seeking fees. And it's like, come on, you're being paid by the hour to pursue what I perceive to be an abusive, bad faith, non-compete case. I'm not being paid anything when I represent sort of poor people and indigent people. In fact, I'm paying out of pocket for litigation costs, and you're going to knock me for saying, hey, if I win, at the end of the day, I'm going to go after my fees. And that's important from a public policy standpoint because it creates a bit of a stick. There has to be some kind of penalty. There has to be some kind of enforcement mechanism, some kind of pain inflicted to prevent people from doing this. And, I'm not the only one saying that, right? The state of Virginia just passed non-compete reform. In my view, it doesn't go far enough, but one of the things that it does is it creates a penalty regime so that when companies seek to enforce non-compete agreements against folks who make below a certain dollar threshold, those folks are entitled to the defendants, right? They're entitled to a broad range of damages. They actually can sue the company for trying to enforce the non-compete, and they can actually get liquidated damages. There's a statutory penalty regime. That's the direction that everything needs to ultimately move in. But until we get there, you can, as sort of a private attorney general, you can, create that regime by taking these cases pro bono on a contingent hourly basis. And then, you have to be willing to invest and commit and go the distance. But if you do and you prevail, and there are all the resources you need, just in terms of cases that I have litigated and cases that I cite in my briefs and blog posts and videos and articles, you can literally study the content that I have put out, and you can study the cases I have litigated, and you should be able to find enough there, to have a good fighting shot in defending, almost any of these sort of poor person non-compete cases, right? And anything short of like somebody stole a bunch of stuff and walked out the door, okay? Those, yeah, that's a different sort of wheelhouse. But the sort of ordinary, oh, this factory worker had a non-compete, now he's working at another factory and we're suing, right? You should be able to defend that and win and seek your full fees, and not only seek your full fees, but also seek a fee multiplier. And in connection with that, you take on these types of cases and causes, you need to thoroughly vet any and all defenses that are predicated on breach of contract, misclassification of the employee as 1099 versus W-2, failure to pay wages, prior breach, unclean hands. All of this is in the mix, and it can be done. Look, it's been hard, and I've been doing it for the past decade, and I've made a lot of enemies. And I've had some win some, lose some, but generally won more than I've lost. But it can be done, and so that's the landscape. That's where it's at. Those are my thoughts for all the folks out there who have been laid off and still threatened with or subject to a non-compete agreement. Jonathan Pollard, Fort Lauderdale, Florida. Have a great day.